Ladies and gentlemen, welcome to this inaugural event of the DVC Trust Estates and Succession series. This series was actually initiated with the purpose of creating a forum for different stakeholders and different professionals in this area of law and practice. So actually just taking a very quick look around the room, we can see that today we have basically solicitors, professional administrators, and professional trustees as well. And to those of you who are here for the very first time, may I extend to you a very, very warm welcome. And to all of the familiar faces, thank you for your continued support, and we hope to see you in even further events in this series. Now, the topic that we've actually chosen today to kick off the series is a very topical issue that is of a lot of practical significance to practitioners in this area, namely how to exercise discretion when distributing and dealing with trust assets. Now, discretion, as we all know, would have been intended by those creating a trust or setting up a will for the best intentions, right? They may want to preserve some degree of flexibility in terms of dealing with assets. Of course, a lot of times it's really for tax efficiency as well. But nevertheless, it was created with good intentions. The problem, of course, practitioners, many of you seated here will know, is that it really becomes a headache when it comes to actual administration because, where you have a general discretion, you don't really get a lot of concrete guidelines as to how you should actually navigate and how you should actually exercise the powers and discretion that's actually given. And so today we aim to discuss and explore really the boundaries of such discretion. And we focus, hopefully, to highlight two aspects. On the one hand, we wish to know what are outside the bounds of such discretion, right? So even though prima facie there is such a discretion, what are outside the bounds? And secondly, we also want to know what actions are actually permissible, which are within the bounds of discretion, so as to give a bit of guidance as to how such powers and discretion can be exercised. And as we will come to see, in this area, there's actually a tension, right? And the tension is between, on the one hand, a pro-regulatory attitude to intervene and try to protect the interests of beneficiaries, and on the other hand, the desire to actually respect and give effect to parties' wishes, in particular the settlor's wishes, and to respect parties' autonomy when structuring affairs. And this tension I've just mentioned really shape the boundaries that we're going to look at today. Now, we're very pleased and honored to have Alfred with us today as our guest speaker. And as many of you will know, Alfred is not only a seasoned litigator and legal advisor, he also has extensive experience acting as professional administrator. Now, this talk, of course, is really intended to be a conversation starter. All right, we don't really propose to go into it too much in depth. It's really to provide some food for thought so that all of you and all of us, when we proceed onwards to drinks and mingle later, we have something to discuss. So Alfred will start off with some practical observations, and then Joshua and I will perhaps go into a bit more of the technical discussion. So on that note, may I invite Alfred to kickstart the matter for us? So Alfred, yeah.
Okay, I will start. First of all, it's actually quite embarrassing for you to introduce me as a seasoned litigator when we have a room full of really seasoned litigators, a lot of whom I learned quite a big deal in the course of my professional career. And I take this opportunity to thank you all for letting me learn from you how to be a litigator. But in terms of professional trustee exercising their discretion, before the talk today, I have actually taken the liberty of doing a little mini survey of bringing this subject with various people who had the opportunity to see me. And I asked, what would be the biggest power and discretion that the trustee would make in administering the trust? Would anyone have any suggestion? What do you think is the biggest power? Would it be power of acquisition or power of management, investment? Any idea? If no, then I would just bring up one subject that I think a lot of people would agree with me would be slightly of a headache. Distribution. Distribution, when is it that it's going to be the good time for distribution, whether to make a distribution or not, how much, to whom? These are all sometimes it will give a lot of headache, especially when you have the beneficiaries knocking on your door and say, I need money. Can I have some money? When am I going to have money? I still remember in the past, I also always use it as an example to say, this estate planning requires a lot of careful consideration. And this example is not about making distribution. It's the inability to make distribution. The story is that someone passed away, being a pilot, leaving one ex-wife, one girlfriend, one child's mother, and like 4 children. All of them are in education, and he had always been providing for them in the course of his lifetime. After he passed away, before he passed away, he made a very romantic decision. That is marrying his wife, then girlfriend, now wife. And the practical effect of this marriage is that all the wills that he had made was revoked. And because of that, given that he's Australian, we have a very complicated probate process. And during that around 6 months to 9 months of applying for probate, we constantly receive calls from beneficiaries asking, when am I going to get the money? Because the school has been calling me every single day, asking me for the school fees. Not that I do not want to give you money, but I haven't gotten the probate. And it is not an easy probate because I need to get all these documents. I'm not going to bore you with the probate application. But what I want to highlight is that sometimes making distribution itself is already a complicated subject that a lot of trustees are scratching their head. And therefore, when we are exercising the discretion, I always say, the first and foremost, and if you disagree with me, please feel free to raise your hand. The first and foremost is to keep a proper record. In the next hour or so, Kerby and Joshua will be sharing with you some cases and examining the decision, the logic behind. And one thing that I can assure you is that if any of the discretionary power that you exercised are not properly documented, you will have a problem explaining to court because your action will be microscopically scrutinized by the court and by the other side. And I'm sure that a lot of litigators here would agree with me that we are quite good at blowing up everything to a magnitude that will justify a litigation. That's why for those who are doing their job as a professional trustee on a daily basis, if you agree with me, I think one of the things that you want to avoid is litigation. Avoid litigation is something that we want to achieve by this 1-hour seminar today. And I hope that you can get something out of this. And as we said, a conversational starter. If there's anything that you want to discuss with us, feel free to reach out to us. I know that I'm not in a position to go after you, shake hands and say, I'm Alfred, this is Kerby. Feel free to ask us any question. But at the end, I know you will know where to find me. Feel free to add me on your LinkedIn and keep in touch on this, okay? The first slides that we are going to talk about is the acquisition, management, and migration and transfer. In the course of the administration of the respective of a trust or estate, there is an ongoing duty to manage the properties, trust property properly, and making sure that it is protected. And I'm sure that a lot of professional trustees will agree with me that if we are talking about some straightforward assets like cash, it is not that much of the work to do. In the nowadays, when the interest rate is so high, all you have to do is to put it in a safe deposit, a fixed deposit, and you can enjoy at least like 4% or 5% return. That makes the job much easier. But that's not always the case if you remember like last year or the year before. We're already talking about a very low interest rate for a very long period of time. And therefore, how to preserve the assets become a topic. And a lot of time, the easiest way to do is to have an investment advisor. But having an investment management and advisor doesn't mean that we are already off the hook. And that is particularly the case when the trustee is part of a bank who is managing a private client, a private bank portfolio. What is the job of the trustee? How is it in conflict with the bank as the investment manager? And I don't have to talk about the DBS case today, but I'm sure that all of you are aware of the significance or the consequences of it. And which is where the anti-Bartlett clause is in place, and we are talking about the Bartlett duty here. In terms of preserving and management of the assets, the trustee always put in all the anti-Bartlett clause in order to protect themselves, basically saying that they are not responsible for any of the losses suffered from the investment. But after the DBS case, we already know that just because there's an anti-Bartlett clause doesn't mean that you are immune. So having the structure in place to make sure that you're not responsible for it become a very sensitive issue. And not to mention that a lot of time when trustees are exercising their power and discretion to make distribution, sometimes instead of making distribution, they would make a loan to the beneficiary. Later on, they may consider forgiving the loan. It can be for administration reason, but more often it is driven by tax reason. Especially when we are talking about beneficiaries moving or living in a high tax jurisdiction. We'll be looking at what is the potential liabilities from the trustee point of view and from the beneficiary's point of view. And especially when we are talking about a multi-million US dollar or even $1 billion of trust, making distribution may involve a lot of advisors, including tax advisors. So in the course of exercising the discretion, you will be subject to a lot of requests or advice from various advisors over whether to do certain things or not. And sometimes, how is it going to be in line with the trustee duty to manage and preserve the assets or making distribution properly? In this respect, I just want to mention that just because you're making a loan to the beneficiaries doesn't mean that you're already off the hook, because ultimately, if the loan is not properly documented, and the most important point is the terms, it might be subject to attack later on, with the transaction being either as avoidable or is indeed a gift. This is particularly the case when we are talking about whether a loan is given or advanced to a beneficiary who later on subject to a matrimonial dispute. Whether this is a loan, a proper loan, or indeed a distribution. Again, when we are talking about a subject of divorce, everything of the beneficiary will be subject to scrutiny. The most common excuse for the beneficiary to say, oh, this is actually not my property, or I'm not privy to the trust assets. That is to shield against potential spousal claim. But if this is not managed properly, this argument may fail. And the last thing you want is to be brought into as the third party in these matrimonial proceedings. So again, to emphasize the importance of having the decision made properly so that later on it will be properly answered in case you are becoming a part of a litigation. Okay. Investment. Let's talk about what would be the Section 4 of the Trustee Ordinance. Does anyone have any idea about what is Section 4? Because most of the professional trustees actually don't care about Section 4 anymore because they are properly protected with the terms of the trustee. In the trustee, most of the time it is properly drafted by lawyers, making it like 40 pages, hundreds of terms. The purpose of it is to protect the trustee against any loss arising from the investment. But then again, at the same time, it is very important for the trustee to have proper documentation, just to show to the court that you have taken all this into consideration, including what we've just mentioned here, the suitability of investment and diversification of portfolio. At the end of the day, the trustee primary position in terms of the investment must be that it is capital preservation, unless they have specific mandate from the settler or the family to take a more aggressive investment strategy for capital appreciation or wealth accumulation. Even if this is the family wishes, it doesn't mean that you can already follow the instructions, follow the mandate, and discharge yourself from liabilities, because this is particularly the case when the matriarch and the patriarch is becoming old. There are other family members involved. The ongoing investment strategy, with or without the investment manager, may no longer be applicable. And that is the case especially when sometimes senior members may not be very obvious that they are losing their capacity. If the cases that I've come across so many times that I have a senior member of the family talking to me very nicely, asking me what I'm doing, what I do and all this, without knowing that actually he or she has been repeating himself or herself. And they become susceptible to other family members' influence. And this is exactly the case that the trustee is required to look into the family composition and situation in order to reassess whether the investment portfolio is suitable for the purpose of the family. And in terms of the sale, I think this is more for the professional trustee or administrator, because in our appointment, we have come across many cases that we need to sell the properties, especially when we talk about estate. How are we going to make sure that the sale will not be criticized in future by the beneficiaries? When we are talking about obtaining the best price, the most common way would be probably to obtain an auction, do it by public auction, easiest, because probably we send it to the auction house will be publicizing it, and then whether it will be auctioned away entirely up to the auction house. It's easy. But then we have come across so many situations, especially when the property is not in such a nice and a desirable situation, state, that it is not easy to find an interested buyer. And for these circumstances, how are we going to obtain a best price? And even if we are going to accept a bid that is lower than the market value, maybe substantiated by the professional valuer, how are we going to make this decision to sell, balancing the interests of the estate and the beneficiaries versus our risk of being accused of selling it as without obtaining the best price? I think that ultimately, again, I have to emphasize, we have to consider all the relevant circumstances, and not only that, maintaining a communication channel with the beneficiaries is actually the key. Having the beneficiaries understanding where we're coming from, what is our role, what is it that we need to do to balance all the interests of all the beneficiaries in order to achieve an outcome that ultimately may not, even if it is not for the best price, but at least it is not attracting any lawsuit against ourselves as professional administrator. And this is what we say earlier. Again, if we are getting we were getting sued by the beneficiaries, how are we going to answer to the potential scrutiny by the court, especially when we are under attack? And in that respect, of course, in the course of our administration of the estate or trust, we have the authorities. These authorities are either from the trustee ordinance or from the trustee to engage professionals. But just because we are empowered to engage professionals, does it mean that we are officially off the hook? A lot of time, what I actually remember when I started doing trust is that a lot of trustees would be amenable to the settler's request to appoint themselves as the investment advisor or manager, so that the settler will retain maximum control or discretion over how to invest the trust assets. I think this was at the time, I'm a little bit too old for that, but then that was at the time when reserve power trust was not even available under the Hong Kong law. It was common in offshore jurisdiction, but not under the Hong Kong law. And we only changed the law, the trustee ordinance. Can you remind me, right? It's 2016, right?
Yeah.
Yeah, 2016 to have the reserve power trust. But then whether the settler is the best person to exercise this investment decision sometimes depends on whether he has the qualification. And of course, not every family has someone who is trained to make the investment. So what would be our role in making sure that the trust assets are properly preserved without offending the person who is setting up trust, that is our client, would be something that we need to look very carefully into. And if necessary, we are open to give advice and on what needs to be done. And I think I have taken too much of your time already. I'll pass it back to Kerby to talk about will laws.
Oh. No, not at all. I mean, that's the point of having a conversation starter, just practical observation. So thank you for talking about the various roles and function of how discretion can actually work and what role it plays. Now we will then go on to the more technical bits, right? So I'll start by discussing some of the positive guiding factors for exercising discretion. And given the limited time, I think we'll just focus on 4 main factors, which are positive in the sense that they give guidance as to how discretion could actually be exercised. Now, the first factor, if we can call it that, is really this: equity is equality, or equity equals equality, right? Quite a catchy 3-word phrase. Now, to many of you here, I'm sure this is very familiar. It is an equitable maxim, right? It is a very well-established maxim. It is frequently applied by courts when dealing with property in the equitable context, in exercise of its equitable jurisdiction. Most commonly used, one very common example is the common intention constructive trust. This is really the maxim they relied upon as the starting point where you have co-ownership of property. Now, when it is applied to discretionary trust, it is really a fallback position, all right? It is a sensible way of dealing with property when you have a family trust that is of relatively limited size, all right? So the objects are relatively small, you know who they are, and this is a good fallback position if you don't have any other guiding factor. The problem, of course, is that it is not always suitable, all right? So as you can see here, you say that it sometimes could actually cause injustice because it could be contrary to the settlor's wishes, all right? So the case there that is actually noted is the classic case, McPhail and Dalton. It's a case where basically there was a trust that was set up for the employees of a company and the dependents as well as relatives of the employees of a relatively large company, all right? So just looking at it, taking a step back, immediately one will be aware, this is going to be no mean feat trying to ascertain all the objects or beneficiaries, potential beneficiaries of this trust, right? You're talking about relatives, dependents of the employees of a family. So the argument there, the issue there was whether this equality equals to this, this maxim should actually be relied upon, because if this maxim is actually applicable, the trust could potentially fail because all the objects is just too wide to ascertain. The House of Lords in that case, basically, it was a very contentious decision, but the majority of the House of Lords ruled to say that actually the test of certainty is not to ascertain each and every single object of that class. Rather, it is sufficient if it could be said whether or not a particular individual is or is not an object. All right, so that description of the employees, dependents, and relatives, any given individual, it is possible to say whether he or she is or is not, then it is fine. And in discussing this, in laying down this test of certainty, basically the House of Lords also said and rejected the presumption that equality is equity, and that somehow this equality principle can apply in all different situations, right? So obviously, where the full class of objects is not ascertainable, this is not a good fallback position. Now, the second example here is given is where the settlor's wishes or the testator's wishes is actually quite clear that the entire trust or estate should be kept whole, all right? So one example is the older case of Mosley and Mosley. Basically, in that case, what happened was a discretion was given to the trustee executor to pick a successor whom the trustee actually felt was the most hopeful, the most promising, and really the best candidate to be the successor of the entire family wealth, right? And the intention there was actually very clear. It was not to split up the family assets, right? It's all the assets should go to the successor so that it can be preserved for the family legacy. So again, in those cases, it's obviously not appropriate to resort to these sorts of maxims as a fallback. A third is, of course, the timing, in the sense that sometimes it may be premature to actually apply this fallback position. And what do we mean by that? It's that before we can actually apply this maxim or resort to just sort of equal distribution, one actually has to first of all ascertain the full class of objects and beneficiaries. All right? And in case in point, a recent case that I was doing, there was a professional administrator administrating an estate. The estate, the deceased was a very successful businessman. One of his most valuable assets was a entire sort of commercial building in the heart of Causeway Bay. So that was obviously worth quite a bit. And the deceased passed away. He left his wife and a concubine, whom they actually married under Chinese customary law, so many decades ago. The administrator, of course, was faced with requests by beneficiaries to distributions, all right, and it was inclined to, of course, apply this sort of equal distribution based on the terms of the trust, which was set up in the will. The problem, however, was that actually under Chinese customary law, I'm not going into details here, but if the wife passed away during the lifetime of the man, right, the deceased, it was possible for the concubine to be elevated to the status of a wife. So this obviously could have usurped the entire sort of distribution framework as to who is entitled to how much, given the way distributions were actually planned and allocated under the will. So therefore, the advice then given was that we need to seek directions, and that was what was done. And that, again, allowed for the proper exercise of discretion. So the point to really take home here is that, in trying to decide how to distribute and whether or not, this sort of distribution a maxim should actually apply, one actually has to ascertain the full class of objects. Now, the second factor, and perhaps one would say is the most important one, is the settlor's wishes, all right? And there are three main sources, right? The first is the obvious one, express provisions in trusts and wills. The second is a separate statement or letter of wishes, all right? And the third is, of course, presumed intentions. We, of course, start with express provisions in the trust or in the will. And insofar as this is concerned, really, this is really just a matter of construction interpretation. And a lot of authorities lay down the principles, but I think there are just really 2 points to distill from the authorities. The first is that basically you apply the same approach to interpreting wills and trusts as you would apply to normal, contractual interpretation as well as other documents. The second is the caveat, right? So this general principle is subject to the caveat that if you're dealing with wills, which is a lot of times how trusts are set up, so basically testamentary trusts in Hong Kong, you have to pay attention to Section 23, capital B of the Wills Ordinance, right? Which basically says that the subjective intentions, which are generally excluded, could be taken into account in cases where there is meaningless words used, or prima facie meaningless, superfluous words used, or where there is ambiguity, all right, in the trust or in the will, and that becomes something that the court can then take into account, subjective intentions, and basically just give respect to that. The second, and perhaps the more contentious one, you can see from the number of subpoints, is the statement of wishes or letter of wishes, all right? So older authorities say that actually it is uncertain as to whether or not this is something to be taken into account. So for a long time, it was just, a separate statement, was just something potentially relevant, all right? They wouldn't really go so far as to say it's necessarily something relevant. But the more recent authorities have actually confirmed that this is definitely that is relevant. And reading textbooks, you will see, Lewin, Snells, and so on, would actually say that this is something that must be taken into account, all right? Now, the distinction, of course, is that something that must be taken into account is not necessarily something that must be followed. So there's a distinction there, all right? So something the trustee take into account doesn't mean that that is binding on the trustee, all right? And, on the contrary, it's actually not binding. It's just one of the various factors. A number of sub-issues arise. The first, of course, is a simple one, whether there's any formalities. The short answer is no. There is no strict form as to what the statement or letter of wishes should take. So it could be an informal letter, all right? It could be, of course, a formal deed, right? Sometimes if it's legally prepared, it could be that. Or it could be just some informal writings, even in diaries, or some sort of scribbles, etc. The second point to note is that it cannot override independent judgment. So that goes back to the point I was mentioning earlier. This is a factor that must be taken into account, but it is not a factor that must be adhered to, must be followed, or is somehow binding on the trustee. On the contrary, the trustee must retain their independent judgment. Now, the third is what is called here subsequent statement, all right, or basically intentions or wishes of the settlor that were expressed after the creation of the trust. And this is perhaps one of the more interesting factors, because if we think about it, if the settlor's wishes that were expressed after the creation of the trust is something that should be given, well, even if it's not binding, given a lot of weight, all right, a weighty factor in the sort of overall consideration, this could then lead to the situation where the settlor essentially retains control, right? Because the settlor could then consistently tell the trustee or the executor how the trust assets or the assets under the estate should be dealt with, and the trustee will be bound to take into account. So this then could lead to some rather absurd situation. And this particular question was actually explored and dealt with in the case of the very recent case, Privy Council, Granville Private Trust and Yeung, which perhaps many of you here would be familiar with. This is also a very interesting case. I was just telling Alfred earlier, because the facts and the issues of this case actually quite closely mirror a saga, which Joshua and Alfred and I, we were actually working on currently. And of course, we want to refrain from discussing ongoing cases, so this is actually a very good proxy for us to discuss the issues. Now, very briefly, the main issue in this case was whether the trustee could properly remove, well, there's a power to add and remove beneficiaries. So what this trustee did was to remove all the existing beneficiaries of a family trust, add a purpose trust, which is basically a charitable purpose trust, as the object, as a sole object, and then transfer the entire trust fund to this charitable purpose trust. Now, the reasoning as to why the trustee actually did that was because according to the settlor were the founders of a very large and famous company in Taiwan called the Formosa Plastics Group, right? It's very valuable. Now, according to the founder settlers, they expressed their wishes that after the creation of the trust, they decided to do their estate planning in such a way that the shares that they hold personally under their own name would be inherited by their descendants, all right? So originally, this family trust that was set up was a way to benefit the descendants. But because of the change in sort of the estate planning, which is to, by way of succession and inheritance instead of through a sort of living trust, the settlers therefore told the trustee to say, well, it's no longer necessary for me, for there to be such a living trust in favor of the beneficiary. So could you please just transfer all the assets to a purpose trust? The purpose trust was for really the public good, charitable purpose, and so on, and not for the family members. So the trustee wanted to, follow the settlers' trust. In fact, they did. The family members challenged this. Now, in terms of reasoning, the Privy Council, first of all, distinguished between three different duties, and that is a very good sort of guideline. Just as we mentioned, there are threefold duty. The first duty is what we call the scope of power rule, right? Basically, trustee must act within the express or implied power that's given to them under the instrument. The second is what is called the relevant considerations rule, which is to consider only relevant considerations and exclude irrelevant ones. The third is what is called the proper purpose rule, all right, which is to exercise powers for proper purpose and not for illegitimate motives. And in this case, the family members were challenging the exercise of this discretion by the first and third rule, which is the proper purpose rule as well as the scope of power rule. They didn't really challenge it through the second limb because the reason is actually obvious, because it is a relevant consideration. The trustee did take into account relevant consideration, which is the settlor's wishes. So you can't really say that, they've somehow not taken into account relevant considerations or taken into account irrelevant ones. The Privy Council then held that basically the trustee was in breach of the proper purpose rule. And one important point, and going back to what we're saying here, is that while the settlor's wishes that were expressed at the time of the creation of a trust was actually relevant in trying to determine the purpose of the trust, the subsequent wishes that were expressed were not relevant, right? So in determining what is the proper purpose of a power or discretion, one only looks at the wishes that were expressed that was contemporaneous at the time of creation of the trust. And so when we look at the purpose, and then the Privy Council went on to say that basically at the time when the trust was created, it was meant to be a family trust to benefit the family members and descendants, and there was you can't therefore exercise the powers to exclude and remove all the family members. All right, and the Privy Council also considered that the power to add and remove beneficiaries could be actually exercised in situations which is for the benefit of those beneficiaries. So, for example, you may want to add in spouses or stepchildren or so on, people whom the beneficiaries have a moral obligation to take care, right? And for removal, sometimes it could be for tax reasons, right? If the continued inclusion would increase tax, then it's a valid reason to remove. So that is, sort of the gist of insofar as this particular point is concerned, that was extracted from there. Now, moving very quickly, the fourth sort of sub-issue is, basically we talk about settlors, but then the question is, who are the settlors? Right? We know that a lot of times, whether it's for tax reasons or for privacy reasons or just for administrative convenience, the paper settlor, the settlor that appears on the trust deed or the will, is not the real settlor, right? And that was the case, in fact, in the Granville and Wong case, and that's also the case that we are actually doing. So basically, in short, equity looks at form. Equity looks at substance, not form. All right. So it is really focusing on who is substantively the real person, the real sort of owner who created the trust. That will be the real settlors, and in that case, of course, it will be the founders of the company. The fifth point is an open point. It's about conflict with express trust of will and trust. Now, this is not something that was expressly discussed in the cases. There is some New Zealand authorities that seem to suggest for the, one would have thought, well, should it be obvious that if the letter of wishes somehow contradict the express terms of the will or trust, that then, that shouldn't be given a lot of weight. That would presumably be the result, and there is some New Zealand authorities to support that. But when it comes to wills, then one should be aware of, again, the effect of Section 23B, right, where there is ambiguity. One basically can look at subjective intentions, which include letter of wishes, and give effect to the letter of wishes. The final sort of source is really presumed intentions. And the case here that's cited is a case which I did involving sort of foreign tax, inheritance tax in the UK. Basically, in that case, the court looked at the will that was set up in terms of distribution. That didn't make clear how foreign estate duties or inheritance tax should be paid. And in that case, the court really focused on the fact that when we are trying to construe a will, we look not just at what is actually there, we also look at what is the presumed intentions, okay? So although the starting point is the wording, one can presume it based on the overall structure, and in that case, it was held that the presumed intention was that the foreign tax should be paid by the Hong Kong part of the estate as well. Right, so moving very quickly, the third sort of factor to guide the exercise of discretion is the beneficiary's wishes and needs, right? So the starting point is that generally speaking, there is no entitlement of discretionary beneficiaries to any property, all right? So their only right is really to have the trust properly administered, right? So remember the threefold duty that we just discussed, but basically that those duties are actually exercised and that there is a proper consideration of how powers or discretion ought to be exercised. Generally, again, there's actually no duty to consult beneficiaries' wishes, and in fact, sometimes you get a will or trustee that expressly excludes the need to consult beneficiaries. Now, that is, of course, theory. But in practice, I'm sure all of you seated here will know, in practice, it would take a very brave, or one might even say reckless, administrator or trustee to not ask for the views of beneficiaries, especially where it is likely that beneficiaries are going to be in disagreement, and you would therefore need to seek court's direction. Because although generally speaking there's no duty to consult, it's subject to a big caveat, which is that if you make a court application for court's direction as to how you exercise the discretion, then you are expected as a trustee or administrator to fully canvass the views of the beneficiaries as to a proposed course of conduct and to put it before the court for consideration. All right? Now, assuming the views are actually obtained, the weight that is given to it is pretty much similar to what you would give to a settlor's wishes, which is that it is very material, but it's not binding. Impartiality, now, generally speaking, I mean, the authority is relatively clear. It doesn't apply where you're talking about discretionary trust. The rationale is relatively simple because discretionary trust, you are expressly obliged to discriminate between different beneficiaries. All right? All the beneficiaries, that's one question, which is what if all the beneficiaries collectively directs a trustee or administrator to do a particular course of action? As a matter of law, as a matter of principle, the answer is no. Beneficiaries, even if it's all the objects under a discretionary trust, cannot give directions as to how a particular discretion or power can be exercised. There is limited exception. I think the authorities say, for example, on voting, exercise of voting power on shares, somehow there is carved out as an exception. But even that is somewhat suspect because I think the cases discussing that also made clear that the authority in those sort of contexts actually were more towards bare trust and not really discretionary trust. But of course, that doesn't mean that the beneficiaries collectively do not have a right. They do. They have a right under what is well established, the Zonders-Vautier rule. They can collapse the trust and demand for the delivery up of the trust assets. And of course, there is also the flip side to consider, which is that although the trustee administrator is not obliged to follow the beneficiary's direction, it doesn't prevent them in the situation where you have sort of unanimous consent amongst beneficiaries and in a properly written form to actually proceed on those unanimous consent, to save cost and time. So it's doable in that way. Now, one issue to perhaps think about, which is not in the slide, but just discussing what we talked about in terms of settlers' wishes, is sort of the interaction between beneficiaries' wishes and settlers' wishes. Because, recall what we were just saying earlier, that subsequent wishes of settlers is actually generally not too relevant in terms of purpose. There's actually a potential sort of dilemma or sort of a counterintuitive situation where you would get, which is that the old settlers' wishes, right, which is the wishes expressed at the time of creation of the trust, will be weighty, okay? And then combined with the beneficiaries' wishes, the recent most contemporaneous wishes of the beneficiaries, that would also be weighty. But the contemporaneous or the most recent wishes of the settlor should actually not be given much weight. So there is this sort of counterintuitive situation as to how much or how far, as a matter of degree, should the trustee or administrator be giving weight to the wishes of the beneficiaries, right? The recent wishes, of course, we're talking about, as opposed to the wishes of the settlor, because otherwise then it becomes that they are the one controlling it, okay? Some might think that this is, of course, no problem because the beneficiaries are ultimately the beneficiaries. But some might think that, well, is that, a bit problematic? But that's an open question. All right, finally, factor 4, what in terms of the form of distribution, this is a relatively mundane question. It just basically asks you the distribution be in money or the actual assets, all right? But it gives rise, surprisingly, to quite a few practical problems. And this really depends on a number of factors, and 3 of them are highlighted here. The first is settlers' wishes, all right? So generally speaking, the default position is that distribution should be in specie, all right? But of course, sometimes you will get settlers' wishes which says that it should be distributed after conversion and so on and so forth. And so that should be generally respected. And if a discretion is actually given to the trustee or administrator to actually be able to convert or choose the time of conversion, then again, that should be generally respected as well and not be intervened by the courts. The second is the nature of property, all right? So if it is divisible personal property such as shares, money, cash, and so on and so forth, then again, generally there should be distribution in specie. But this is again subject to a caveat, which is unless there is disproportionate advantage given to one or few of the beneficiaries. And the case in point, the context that's usually used here is where you're talking about shares in a company. And where if you distribute shares to a particular beneficiary, that beneficiary or that few beneficiary in a particular camp would gain majority control. And that may be against what is intended by the settlor, right? The settlor may not have intended for that a few individuals would seize control of the entire company just by that distribution. Now, in those cases, then in specie may not be appropriate. Indivisible property, of course, that is just a sort of a practical implication. If you're talking about things which cannot be easily divisible, as a matter of common law, there is implied trust for sale in those situations. And finally, something which is touched upon by Alfred as well, is the payment of expenses and debts, right? So generally, there's a power of sale by trustees and administrators to sell assets in the course of the administration to pay for various expenses and so on. This is also protected in the form of a trustee's lien, right? So there's actually a sort of a right to the expenses remuneration. And there are a few different rights. There's what is called reimbursement, so payment by the trustee himself, and then followed by reimbursing himself from the trust fund. There is exoneration, which is payment directly from the trust fund. And then there is also sort of retention, which is really retaining certain assets for the actual, or more importantly, contingent liabilities that could arise in the future. And finally, there's this power of realization, which is that the trustee does not actually have to wait until the property are sold. He or she can actually actively exercise this power of the lien in order to get his expenses or remuneration insofar as the administration of trust is concerned. All right, so very quickly, we'll move on then to the negative factors, and I'll pass on to Joshua. Yeah.
Thank you, Kerby. I'll now touch upon the negative factors of what we call pitfalls in terms of how the discretion is to be exercised. There are 4 things that I wish to canvass in the little time remaining, but I think they are all very useful to act as the boundaries and the red flags for how everyone decides to distribute assets and how everyone decides to exercise powers. So now the first pitfall that I wish to discuss is actually a very recent and a very interesting phenomenon. When preparing for this talk, I was actually very surprised to find Lewin's latest edition actually has a section specifically on the exercise of this power. Now, the form or the provision of a power within a trust deed to allow a trustee to transfer the assets away entirely was described by the editors as a common power in modern discretionary settlements. And so it's something that's highly relevant to the context nowadays and to the powers that a trustee may be exercised. Now, the guiding principles for this power are still in their infancy. There's not a lot of settled dicta, but generally the trite legal principles that Alfred and Kerby have already discussed in terms of how power should be exercised would apply. But one key point here is the constitution and the beneficiaries of both trusts might differ based on the facts. So now the case of Grandview Private Trusts that Kerby mentioned earlier is actually a good example because if you recall the facts that he very helpfully outlined, the initial trust was for a discretionary trust for the family, and the subsequent trust was actually a charitable purpose trust. Now, the change in beneficiaries completely was something that raised eyebrows, obviously, on the facts of that case, and was something that the trustee had to justify with the various considerations that ultimately did not work out at the Privy Council. But it's very important to compare the terms and the specifics of both trusts. Now, Lewin generally says that the power has to be exercised for the benefit of one or more beneficiaries. But the way this is framed and considered and determined must be through how these two different trust structures are administered, what protections the beneficiaries have, who are the beneficiaries in both structures, and what difficulty will they have in terms of enforcing their rights, and what jurisdiction both trusts are from. These are all material and pertinent factors that would affect the way up in terms of how these two trusts operate and how the transfer can or cannot be justified. So although albeit novel and seemingly simple, one can immediately appreciate why this is a hot topic and why this is something we wish to bring up for discussion, because there are layers upon layers of complexity in terms of how each trust operates, the foreign law advice that's probably involved, if there is, say, an offshore trust or a specific purpose trust, as in the case in Grandview, and how trustees can come to these decisions. And so this is, first and foremost, one thing I wish to highlight from the get-go as an area that is up and coming, and an area that probably will be fertile ground for litigation in the future if and when trustees actually make these decisions. So it's definitely something worth highlighting. Now, this dovetails into my second point, which is a more general point and a more general area of consideration, which is fettering of discretion. Now, the concept itself is inherent in the idea of a discretionary trust. If the powers given to the trustee are discretionary, they can't impose fetters or straitjackets into how these are exercised. Now, the question is quite often how and what the boundaries are, as Kerby mentioned earlier. Now, I wish to start off by highlighting, and I think Alfred actually, in his wisdom, foreshadowed this, 2 key points in terms of how to avoid this pitfall. The first and the most obvious one, as Alfred said, is to keep good records and to keep evidence of consideration. Now, quite often it's easy for decisions to be made, especially if different beneficiaries are pestering, are asking, are making requests, quite often perhaps even for the same outcome. But it is important to evidence the independent thought process and the various factors that are actually considered by the trustee, because this is the key in defending whether or not the discretion was actually exercised in an independent manner. Now, the second key point, which is also important and which Alfred also in his wisdom highlighted, is to keep communication with beneficiaries. Because when there are responses and when there is the ebb and flow of information and ideas and reasons, this is how one can show that there was genuine consideration of the position of different people, and how a trustee can show that there was actual thought into the decision that was ultimately made. Now, the way this manifests is into the 4 points on the left and the 2 points on the right that I just wish to quickly go through. Now, the 4 points on the left are actually a snapshot of what duties a trustee generally has, and I believe everyone here probably needs no reminder as to how these duties are generally framed. But I think the key takeaway and the key point I wish to highlight, as Kerby mentioned, there is a 3-part structure laid down by the Privy Council in Grand View about how powers are to be exercised. And the second of the 3 duties, as Kerby frames them, is actually this duty to take into account all relevant considerations and not fetter discretion. So it's very important in deciding or in making decisions to avoid this pitfall. Now, I wish to highlight a point here, which is quite often it is a paradoxical in a way in how a trustee can exercise powers. The reason is you have, as Kerby mentioned, to take into account a host of relevant factors, a host of weighty, often material considerations. But at the same time, you have to be guided but not bound by them. And the proverbial gray area between these two concepts that might often overlap is what creates difficulty and what creates room for fertile litigation. Now, however, there is one thing I wish to highlight, which is given that this is a discretionary structure, there is a degree of leeway given to trustees in the law, where if the decision is a reasonable one, and these are the words used in the seminal judgment of Mr. Justice Wilson Chan in the Tao So Ngun against HSBC case, he mentions that they are not subject to challenge even if the court would have acted otherwise. And so it's important to lay out the factors and the decision and the different steps in making a determination, because that allows the court to determine whether it's reasonable. And Mr. Justice Wilson Chan also highlighted that a trustee can actually decide on the weight. I think Kerby also hinted at this legal position in terms of what factors in order to, what weight to give what factors. Now, as mentioned, the common fetters of discretion largely mirrors these sort of positive things to take into account, which is why I think it's important to highlight this is a very paradoxical sort of situation for many trustees. But it's important to bear this in mind and important to be alive to the possibility that this is, especially, it's very easy in situations where things are harmonial, where the trust has a modus operandi, where generally beneficiaries are in agreement, trustees just follow. It seems administrative in a sense, but that's often trapped because it's very easy. Well, when things are good and everyone can sing Kumbaya, of course, it's easy to follow and easy to just abide by what beneficiaries say. But when disputes happen, that is when the decisions are challenged, and that is why having good practices and structures, as Alfred highlighted, is key to avoid this second pitfall. Now, the third area or the third pitfall, which I will go through relatively quickly given the time, is the idea of advancements and interim distributions. Now, these are two concepts, but perhaps before I touch and add on them, I'm aware actually that Kerby has done some recent cases in this area, and perhaps he might have something to touch on or chime in first before I sort of wrap up on any additional observations on this specific issue.
Yeah, just actually a very, very quick point, because as we were discussing before the talk, the point is in administering a trust or basically an estate, a lot of times there will be questions that one would need to resolve or actually seek court directions on. Now, as we all know, seeking court directions and litigation takes a lot of time, all right, and that could take years. In the meanwhile, beneficiaries would quite legitimately want to have some payment, right, because the trust is there or the funds are there, and there's no reason why they can't enjoy in the meanwhile. And the sort of observation that one actually gets from a few recent cases that I've been involved in is that there is a general sort of presumption by the court that these sort of interim payments or distributions, even though it's within the discretion of the trustee or administrator, that these interim payments should actually be paid. All right, so this is something that ought to be done. Now, that having said, it is payment of the interim distribution is of course not the same as how much should actually be paid. And in regards to the quantum of payment, that is something which the court will actually defer quite a lot to the judgment and assessment of trustees and administrator. And as the authorities actually say, when we're determining in terms of how much we should be distributing, that a trustee or administrator should actually adopt a cautious approach. All right. So even though it will be very difficult to say that I don't want to make any distribution in the interim, nevertheless, if there are genuine concerns about potential liabilities and debts and expenses and whatnot, that could be genuinely reflected and raised to the court, and to say that, well, although I am okay with making distribution, the amount I need to cut it down because of various concerns or the need to actually retain funds. All right. So that's just something to add.
Thank you, Kerby. That's a very interesting perspective, I think, because as Kerby highlighted, practically speaking, this is probably one of the most common issues in terms of how a trust practically can be administered, because especially with the complexity, the detail, the amount of assets within modern day trust structures, beneficiaries need money to do various things, as all humans in this room do. And it's more often than not that requests for interim distribution or advancements come up. And I think the key point, and this is one thing I wish to highlight, is if you juxtapose these requests against the duties of a trustee in exercising powers that I sort of highlighted in a snapshot in the last slide, the key is, and the difficulty and the pitfall is often, as Kerby mentioned, these are future-looking, in the sense that you have to justify not only the decision to advance based on, or make distribution based on the present needs of beneficiaries. You have to come to an informed and reasoned position as to how the trust or how the trust funds will look in the future, and why this specific amount is justifiable, or why it wouldn't jeopardize or wouldn't bring into issue other aspects of the trust's governance. So that's an extremely delicate balance, because we all don't have the proverbial crystal ball. And it's something that is, I believe, and in experience, quite challenging in order to justify, and yet something that's very pressing. Because if you could just imagine, if you're the trustee, beneficiaries, once their needs arise, you are their first port of call, because they may, under a discretionary trust, have entitlement, and nothing prevents them from asking. And so day in, day out, this is a very practical and significant issue, in my view, that trustees have to bear in mind, and that is another fertile ground for both discussion and litigation in terms of how these things work. Now, just to wrap up very briefly on this issue, there are sort of, this slide talks about both advancements and interim distributions. Obviously, advancements, legally speaking, has its own definition under the trustee ordinance, and you could see some commonly used definitions in the cases. The formulation of the establishment of the life of a beneficiary was recently affirmed by a Court of Appeal in 2020. But the key point, I think, is the way advancements, and another point I wish to highlight is the source of the advancements is often one thing that might be material in terms of the considerations. And the reason is, depending on the trust structure, there might be different assets. For instance, certain investments might generate returns, and there might be certain income that comes from, say, rental or other properties and things like that. Now, these are all relevant, because to give an advancement, if it's taken off something that's recurring, probably there is more justification in terms of how or why that affects the trust. And so in order to justify or explain a decision to advance, a trustee also has to go through a complicated process and dissect and explain how and why this affects the trust fund. And so it's a very important pitfall, and it is something that is quite alive, I think, and must be borne in mind in terms of decision making and in terms of the requests of beneficiaries. I think it ties in very well to all the positive and negative factors we have tried to cover in this talk as well. And so I think that brings quite nicely the threads in terms of the negative factors that I wish to briefly cover.
All right, so that really concludes the seminar part of today's event, which is probably the more boring part. Of course, that is not the end of the event. Well, we see on the slides here Q&A, but I think it might be preferable for instead of facing questions here, why don't we just, I think, move over to where we have some drinks and snacks so that we can all...
We are not accepting questions.
We are accepting questions. We just thought that, people might be thirsty, and I note the time, right? We have been, actually, we're actually quite on time. It's quite good time, yeah. Exactly. So, so why don't we do that, and we can discuss more over drinks. Just a very quick previews, right? So obviously this is a series of talks. We do have other events and talks sort of lined up, and the next one that we actually intend to have is we plan to do it on a quarterly basis. So next one will be sometime in December. At the moment, of course, subject to any other suggestion, we do intend to talk about a bit more of another very practical issue, which is the appointment and replacement of trustees and administrators, and go into a bit more in depth about, say, issues of remuneration, which is also quite, quite a headache, just to put it that way. But anyway, so thank you all for sitting through the talk, and yes, please stay for drinks and mingle. Thank you. Thank you.